Welcome back to Illinois Law. This is a service of the Illinois State Bar Association, and I'm your host, John Tice. We've been talking about cases from the United States Supreme Court from the last term in the last year, and this is part of a three-part series, actually. Today we're talking about some of the cases the court came down with in the last term, and right before the break we were talking about a case in the area of advice of individuals who are might have a criminal case but who have immigration consequences, and the court found that lawyers need to advise them about possible deportation. Judge Murray, in the state of Illinois, what is the procedure when someone has a possible immigration consequence of a case and they're either pleading guilty or they're found guilty of a criminal case?
Well, part of the admonitions that a judge is required to give not only goes to the possible sentence as a result of a plea to a criminal offense, but also the deportation issue that could result if a person is an immigrant and not a U.S. citizen. So that admonition must also be part of the interchange between a judge and a criminal defendant as well.
So as many people know from seeing criminal cases where people plead guilty, they are advised of all their rights at that time. And one of the rights that Illinois, was Illinois doing that before this Padilla case?
Yes. Since I've been on the bench was it 2007, and I believe well beyond that, that was required, and it's part of the Supreme Court rules.
Okay.
And the bottom line here is just that counsel cannot remain silent as to possible deportation consequences when you have a case with these facts.
The person may still end up pleading guilty and taking their chances with immigration, but they need to be at least advised of it.
That's correct.
All right. And
Leonard, can I ask a question?
Sure.
At what point does this admonition need to be given?
It's after the defendant has, you believe that they are voluntarily entering a plea, and there's a series of things you give in terms of waiver, right, trial by jury, on and on and on, and part of this set includes the possible deportation. And it's given even if you don't suspect the person may run that risk. It's just given in every situation.
So we don't rely on counsel to give that information to the defendant?
No. Now, the Padilla case, of course, suggests that counsel has an obligation to give that advise a client of that possible risk. But in Illinois, at least, as a judge, I'm required to also give that notice of that possible risk.
Right. That's under Illinois Supreme Court rule, and Padilla stems from the Sixth Amendment of the U.S. Constitution.
the court weighed in on another immigration issue in the last term as well, didn't they?
Yes,
Michelle?
yes, there was another case.
Why don't you tell us what happened in that case?
Well, in Carachuri-Rosando versus Holder, the court held that immigration judges retain discretion to cancel what would otherwise be an automatic deportation for repeated drug offenses. In this case, a defendant was a native of Mexico, but a lawful permanent resident of the United States since he was 5 years old. He committed 2 unrelated misdemeanor drug possession offenses in Texas. The first was possession for less than 2 ounces of marijuana, which resulted in 20 days in jail, and that was followed by possession without a prescription of 1 tablet of Xanax, which is an anti-anxiety drug, and that resulted in 10 days in jail for him. After the second offense, the federal government started deportation proceedings, and he claimed he was eligible for discretionary relief from removal because he had not been committed of an aggravated felony. The Court of Appeals rejected this and held that a simple drug possession offense is always considered an aggravated felony when committed after a conviction for a first possession offense. Now, the U.S. Supreme Court unanimously reversed this decision and rejected the reasoning. In another opinion authored by Justice Stevens, he reasoned that common sense would not support equating a simple possession conviction that resulted in 10 days in jail with an aggravated felony. And he also said that he believed that the federal government should respect the decision of Texas prosecutors to charge defendant with a misdemeanor and not a felony.
And just, I don't know if you said, but what was the split on that one?
7-2.
Okay. So the what all it really says is the immigration judge it's not automatic.
Oh, no, this was a unanimous. I'm sorry, it was a unanimous
Oh,
case.
okay.
Yes, they all agreed on this one.
Got it. All right.
It's interesting, though, that Justice Stevens would invoke the idea of common sense as
Yes.
a standard.
It's always valuable, even with the United States Supreme Court.
It's good to have.
Professor Cecil Hunt has been looking at a case in the area of labor employment, which is another thing that comes up often in cases from the United States Supreme Court. What was the interesting case from the last term with regard to that, Professor Hunt?
Well, this was Lewis versus the City of Chicago, a second City of Chicago case. Lewis versus the City of Chicago, which was a 9-0 unanimous decision written by Justice Scalia, of all people. Now, in the initial review of this case, it looks like a civil rights case, because this is a situation where the City of Chicago gave an exam, a written exam, for people who wanted to be firefighters, and then set up 3 categories. One was well qualified, which was 88 to 100. One was qualified, 69 to 88, and one was unqualified, if you were below 69. And then they said they were going to draw randomly from the group of well qualified. But then you had a group of African American applicants who brought suit and filed a complaint with the EEOC that said this was discriminatory, and that this was a violation of the disparate impact standard of the of Title VII.
Why don't you just explain briefly what you mean by disparate impact standard? What is that?
Well, Title VII provides that if there is, in fact, a disparate impact on the basis of race, a different impact, a significant impact on African Americans or any minority, then that's a violation of Title VII, and the court has to look very carefully at that.
Even though the language, as I understand, even though the language might be race neutral, if the effect of it is to impact differently on different
disparate effect,
then they can consider that.
Yes.
Okay. And
so
what
this seems like a race case,
right,
but in fact, which is why it's so ironic that Justice Scalia is writing for the majority in a unanimous decision. But in fact, the court says we are not deciding the merits of this case as to whether or not there is a disparate impact or not. We're looking at this as a civil procedure case as to whether or not they have a right to bring this suit, because the city's defense was that more than 300 days had elapsed since the event, the discriminatory event, which was back in 1996. More than 300 days had elapsed, so the city could say that this event, this event of discrimination, was too aged, it was too old, and therefore they had no right to sue. But instead, the Supreme Court said that every time they used the old standard, the old test, to make a decision as to who to give a job as a firefighter to, which they did repeatedly for up to 9 years, they used the old test. Every time they did that, that was a new instance of discrimination, and therefore this suit was timely within 300 days. And the Supreme Court said, that's right, it is timely because every time you do this, this is a new offense. And the City of Chicago said, that's not the case. Even the Seventh Circuit said that's not the case, that the event of discrimination was back in 1996, and that's too old. But this was a procedure case in which they said, you have a right to sue, but we're not deciding whether on the merits you are right or you are wrong.
What's interesting about this decision, if you think back to the Lilly Ledbetter case, where the court suggests that because she was not aware of the discriminatory wage practices of her employer, that her suit was untimely because she didn't know to file the suit during the 300-day window that they talked about here. But of course, the law was changed subsequently to amend the time-barred rules. This is analogous to that.
It is interesting. That was only a couple of years ago.
A couple of years
That's
ago.
right.
They changed the law to, as it would have affected her, of someone like her today.
Right.
But that change in the law isn't why the result was different in this case, right? So
No,
in some ways,
it was analogous, but it wasn't particularly relevant to this case. But the city's position was really quite unusual, in that they were saying, even if this was a discriminatory act back in 1995, even if it was a discriminatory act, we can now treat it as if it was a valid act, because essentially the statute of limitations has run. More than 300 days has run. So it doesn't matter whether we were discriminatory or not. In fact, we may have been discriminatory, but now that we've gone beyond the statute of limitations, there's nothing you can do about it.
And just so that I understand, the act of the city that was in question here was the drafting of the test or the putting together the test?
No, the act of the city was using a test which had a disparate impact on minorities.
Okay.
Now, they said when we first made these categories, that was using the test, and that was a long time ago, back in the 90s. The plaintiffs raised the argument that every time they continued to use the test on through the 2000s, that was in each event a new event of discrimination.
So
And
Lewis was the plaintiff, I assume in this case then,
Yes.
was somebody who had...
one of the 4 firefighters
he would,
who was an African American who said there was a disparate impact on us. And they said this was a new event each time they used it, and they continued to use this test. They went through the well-qualified people, and then they exhausted that pool and started picking from the qualified people. But they were still using the original 1995 test.
okay. So just so that I understand, the ultimate, did the court then send it back to...
Oh yes, the court sent it back for new actions on remand. They reversed and remanded because the Seventh Circuit had upheld the city's view that this was an old act which, although it may have been discriminatory, was time barred.
Right.
So they said, no, take this back down below and have some new findings consistent with this decision.
Well, the court, of course, has interesting cases every term, and this is only the second of 3-part series on cases from the United States Supreme Court from the last term. Thank you very much to our panelists, Professor Cecil Hunt, Michelle Jochner, Judge Leonard Murray, for helping us out to understand these cases from the United States Supreme Court. And thank you very much. This is Illinois Law. This is a service of the Illinois State Bar Association, and I'm your host, John Tice.